heard of them, two fabulous lawyers, politicians, working in many different fields and fighting for many different types of rights for us, to read a section of this beautiful decision from Judge Walker.
Thank you, Jake. And first, just for the record, Todd and I have poured through in about an hour 136 of the most amazing pages of a decision. When Jake said it was beautiful, what I want each of you to do tonight is go home, get a copy of the decision, a bottle of red wine, and read through it. It is uplifting and it is amazing. We just pulled out a couple of the basic parts of it. It's 136 pages. We're just going to read that to you right now, but please check it out in full. So, first of all, in essence, the decision, the issue was, the question presented here is whether the plaintiffs in the California action sought to exercise a fundamental right to marry. It's important to note that the parties did not dispute and the court recognized that this right was a fundamental right, or instead, if because they are couples of the same sex, whether they sought recognition of a new right. And so the court decided.
And here's what the court said. Plaintiffs do not seek recognition of a new right. To characterize plaintiff's objective as the right to same-sex marriage would suggest that plaintiffs seek something different from what opposite-sex couples across the state enjoy, namely marriage. Rather, plaintiffs ask California to recognize their relationships for what they are, marriage. Right. When the court was asked whether the providing domestic partnerships was an adequate equivalent to marriage, the court said the evidence at trial shows that domestic partnerships exist solely to differentiate same-sex unions from marriage. A domestic partnership is not a marriage. While domestic partnerships offer same-sex couples almost all the rights and responsibilities associated with marriage, the evidence shows that the withholding of the designation marriage significantly disadvantages plaintiffs. The record reflects that marriage is a culturally superior status compared to a domestic partnership, and California does not meet its due process obligation to allow plaintiffs to marry by offering them a substitute, an inferior institution that denies marriage to same-sex couples. Marriage is what we want.
So in a 136-page amazing decision, they concluded that Proposition 8 fails to advance any rational basis in singling out gay men and lesbians for denial of marriage licenses. Indeed, the evidence shows Proposition 8 does nothing more than enshrine in the California Constitution the notion that opposite-sex couples are superior to same-sex couples. Is that true? No! Because California has no interest in discriminating against gay men and lesbians. And because Proposition 8 prevents California from fulfilling its constitutional obligation to provide marriage on an equal basis, the court concludes that Proposition 8 is unconstitutional.
What a great day. That the majority of California voters supported Proposition 8 is irrelevant. Because fundamental rights may not be submitted to a vote. They depend on the outcome of no election. So, in concluding, the court said the evidence shows that same-sex marriage has and will have no adverse effects on society or the institution of marriage. And because of that, California has no interest in waiting and no practical need to wait to grant marriage's license to same-sex couples. So guess what?
the day that we elected President Barack Obama, the same day that Prop 8 was also passed. Do you remember that feeling?
Yes.
I remember my feeling of confusion, of hurt, of disgust, of thinking, what is this? I never thought of myself as being unequal before. And now, all of a sudden, hearing these words of this judge and feeling this exhilaration that I do feel, all for being equal, it's amazing. It's amazing. Next up, I would like to introduce two people, one couple, Aaron O'Brien, and I want to make sure I get the name, Dara Barnett, who have been together for almost 8 years and who were married in California and were very much affected by the Prop 8 law.
Good evening, Queer New York. My name is Erin O'Brien. I'm a New York City public school teacher, and this is Dara. When we moved to San Francisco in 2006, we registered as domestic partners. And after that, we were then obligated to pay each other's student loan debt, and we could visit each other in the hospital and in prison. Our futures looked bright. In 2008, when marriage equality came to California, we went to City Hall and we got married. But then we had to wait until November. And while we waited for the election, the Catholic Church and the Mormon Church threw money against our cause. They armed supporters with a religious scorecard that they cast at the ballot, and they cast it against us. Now, I'm a teacher, so I went into school the next day. President Obama had won, and this was celebrated in our schools as an example to our students that all of them could grow up to be anything they wanted. But in the passage of Proposition 8, I looked at my students and I knew that not all of them could marry the person they loved in California. Since then, we have seen a lot of defeat: the voters in Maine, the governor of Hawaii, and the state legislator here in New York. But this summer, with a federal judge in Massachusetts saying that part of the Defense of Marriage Act is unconstitutional, and now Judge Walker's decision in California, we are seeing that judges agree with us. Discrimination cannot be written into law. Civil rights cannot be given to one person and not to other people. We know that we will someday achieve full federal equality, and it just might be another judge that grants it to us. Thank you all for coming out tonight, and thank you, Judge Walker.